All right, let's dive right into this explainer. Today we're looking at what is essentially a tale of two eras in land law. We're talking about a massive, modern plot twist that completely flipped the balance of power between property owners and squatters. We're going to explore how a centuries-old doctrine got dragged kicking and screaming into the modern age, basically building this impenetrable legal fortress for some while leaving others completely exposed.
It's kind of a wild thought, isn't it? Just imagine a total stranger silently moving on to some forgotten corner of your property, they set up camp, and eventually, well, the law literally just hands them the deed. Can someone really legally take your land just by living on it? Honestly, for a very long time, the answer was a resounding yes. I know, it sounds absolutely terrifying if you're a property owner, but to truly grasp why the big legal shift in 2002 was so incredibly revolutionary, we first need to look at the old magic trick that made vanishing property titles possible in the first place.
Which brings us to adverse possession. So, what is this exactly? Basically, it happens when a non-owner is in factual possession of land with a clear intention to possess it. And after a defined period of time, they actually acquire the title, completely wiping out the true owner's rights. Now, we're not just talking about accidentally parking your car on your neighbor's lawn here. No, as we saw in the classic 1977 case, Powell v. McFarland, it requires a true, undeniable intention to possess, like an intent to exclude the world at large. And historically, this whole doctrine wasn't just invented to punish lazy owners. It was actually justified as a way to resolve stale claims, provide some legal certainty, and, crucially, encourage the productive use of what would otherwise just be lost or neglected land. Okay, let's look at the timeline of how this all went down. We've basically got three major milestones to track. First, the 1980 Limitation Act. That represents the old era. Then we hit our main focus for today, the great shift under the 2002 Land Registration Act. And finally, the 2012 LSPO Act, which threw a whole new criminal layer into the mix. So let's trace this evolution and see exactly how it created this modern fortress for landowners. Right, so let's start with those old rules under the Limitation Act 1980. I want you to think of this era as a silent, ticking clock. If a squatter was in adverse possession of land for just 12 years, or 10 years if it was crown land, the paper owner's right to recover that land was completely barred. And here is the absolute kicker. Section 17 provided that once that time expired, the paper owner's title was automatically, silently extinguished. Literally, poof, gone. The true owner could lose their land completely in the dark. There was no warning, no polite letter in the mail. If you didn't happen to notice the squatter, you simply lost the property. If you want to understand the massive stakes involved here, look no further than the famous House of Lords case, J. Pye Oxford Ltd v. Graham back in 2002. Under those old 1980 rules, a registered owner lost agricultural land with huge development potential worth millions of pounds to a squire. And the compensation they got for losing millions? Absolutely zero. Nothing. It perfectly highlights why property owners felt so intensely, deeply vulnerable under that old silent system. A diligent squatter literally just had to outlast the limitation period, and the paper owner's innocent ignorance would lead to a total devastating loss of title. So naturally, because of shocking cases exactly like Pye, the plot had to twist, and it twisted dramatically. The Land Registration Act 2002 came in and fundamentally altered the entire doctrine for registered land. We shifted away from that 1980 silent automatic extinguishment where time just quietly ran out to a brand new active application-based procedure under the 2002 Act. Think of it like this. The new system essentially replaced that silent ticking clock with a blaring active alarm bell. It was completely designed to heavily shield the registered proprietor. Let's break down exactly how this new Schedule 6 machinery actually works, step by step. Under the 2002 Act, mere factual possession, no matter how long it goes on, does not automatically confer title anymore. Instead, after 10 years of possession, the squatter has to actively step out of the shadows and apply to the land registry. Then, the registrar is legally obligated to notify the registered owner. And guys, this is the central innovation. The paper owner is actively warned. So if the owner is paying even a little bit of attention, they simply serve a counter notice to object to the application. Boom, that effectively blocks the squatter and resets the whole clock. But wait a second. What if the owner does object? Is it just game over for the squatter right then and there? Well, almost. The squatter's application gets rejected unless they hold one of three very rare keys. We call these the Schedule 6 exceptions. First, they might win if they have an equity by estoppel, which basically means it would be totally unconscientiable to dispossess them at this point. Or second, they might have some other legal entitlement, like a valid contract. But by far the most common one is the third, the boundary mistake. This is where someone has possessed adjacent land for 10 years, reasonably believing it actually belonged to them.
And, as we saw in the 2011 case of Zarb Viperi, the courts have actually been somewhat flexible here. That reasonable belief, it doesn't even have to be perfectly continuous for the entire decade.
Now get ready for a pretty dramatic twist baked right into the 2002 law, and it revolves around the number 2. This represents the second chance backstop. So let's say a squatter applies, the owner actively objects with a counter notice, and the squatter doesn't meet any of those 3 rare exceptions we just talked about. Naturally, the claim is rejected. But if the owner basically goes back to sleep and fails to take actual legal steps to evict the squatter for a further 2 years, well, the squatter can reapply. And this time around, they will be fully entitled to be registered. So while the new law definitely warns the owner, it absolutely still demands that they get off the couch and take action. As if navigating those 2002 rules wasn't hard enough, cut to a decade later, and squatters faced a massive new dragon to slay. We're talking about Section 144 of the Legal Aid, Sentencing, and Punishment of Offenders Act, better known as LASPO, in 2012. This act created a brand new criminal offense of squatting in a residential building, meaning if you enter as a trespasser and intend to live there, you can now face up to 51 weeks in prison and a hefty fine. This radically altered the risk calculus. It heavily deters squatters because the very act of occupying a home just to start that civil clock ticking could literally land you in handcuffs. And that brings us to this truly fascinating legal paradox. It was perfectly captured in the 2015 Court of Appeal case, R. Best v. Chief Land Registrar. So in this case, Mr. Best had arguably committed the criminal offense under LASPO 2012, but he still went ahead and tried to claim the property civilly. The Chief Land Registrar obviously tried to block him, arguing, hey, we shouldn't be rewarding criminal acts. But the court ruled that the criminal and civil regimes operate completely independently. Section 144 does not override Schedule 6. So, incredibly, a squatter's criminal liability doesn't automatically strip them of the right to establish a civil title. That is, assuming they somehow managed to clear all those massive Schedule 6 hurdles we discussed earlier. Now, a logical question pops up here. Was this massive 2002 shift away from squatters and toward owners somehow forced upon the UK by human rights law? Interestingly, the answer is no. Let's look back at that Pye saga for a second. The original landowner, Pye, was so furious they actually took their multi-million-pound loss all the way to the European Court of Human Rights. But in 2007, the Grand Chamber ruled by a 10-7 majority that the old, harsh, silent extinguishment law was actually fully compliant with human rights. They said it pursued a legitimate aim of legal certainty. And this is a crucial detail, because it proves the 2002 Land Registration Act wasn't just some desperate fix to a human rights violation. No, it was a deliberate, proactive policy choice by Parliament. They chose to prioritize the sanctity of the register and go way, way beyond the bare human rights minimums. So, what's the big takeaway? The crucial point is that we are now left living with 2 very different systems operating side by side. For registered land, under the post-2002 rules, we have that active notice and objection procedure, leaving the owner heavily protected. But the 1980 Limitation Act still completely governs unregistered land today. That means for unregistered land, you still have that silent, automatic extinguishment, and the owner remains highly vulnerable. You could literally have 2 neighboring plots of land playing by entirely different rules, depending purely on whether they happen to be registered. It's definitely an awkward asymmetry, though. To be fair, it's a shrinking one, since land registration is mostly compulsory these days. Which leaves us with this final thought to wrap up today's explainer. We've seen exactly how the Land Registration Act 2002 fundamentally recalibrated the entire balance of power. It put all the initiative right back into the hands of the registered owner, making that silent theft of title practically impossible. But you have to wonder, if the system now so heavily shields registered owners, even the ones who completely neglect their properties for decades, does adverse possession still serve its historic purpose? Is it still encouraging the productive use of land? Or in our quest for a perfect, guaranteed register, have we simply built a fortress that protects stagnation? Definitely something to chew on the next time you walk past an abandoned, overgrown lot. Thanks for joining me on this deep dive.